Hello, everyone. So, welcome back to my English law channel. I'm looking at contract law and particularly the topic of frustration. So, Davis Contractors against Fairham UDC is one of the leading cases on that, and this is what Lord Radcliffe had to say to define frustration. Frustration occurs whenever the law recognises that, without the default of either party, a contractual obligation has become incapable of being performed because of the circumstances in which performance is called for, that would render it a radically different thing from that which was undertaken by the contract. It was not what I promised to do. Close quotation. So something has happened which they didn't provide for, and therefore you can't carry out the contract properly. So both parties are released from their obligations. It's nobody's fault. So a test of whether there's frustration or not is set out by National Carriers Limited and Panalpina Northern Limited 1981. This is what Lord Simon had to say about it. The frustration of a contract takes place when there supervenes an event without default of either party and for which the contract makes no sufficient provision, which so significantly changes the nature, not merely the expense of the onerousness of the outstanding contractual obligations and or rights from which parties could reasonably have contemplated at the time of its execution, that would be unjust to hold them to the literal sense of the stipulations in the new circumstances, and in such case the laws declares that both parties to be discharged from further performance. Close quotations. So when it said execution, it didn't mean judicial killing, it meant carrying out, or in this case, signing the contract, making the contract. So something has happened which made it impossible to fully perform the contract. So let's look at that test bit by bit. First of all, there must be a supervening event, something which happens after the contract was formed. Then it must render the performance of the contract either radically different or totally impossible, as per Davis Contractors against Fairham UDC 1956. That even if you could perform it, you can't perform it properly, fully, not the way you originally imagined. And it must be something for which the contract doesn't make any proper provision. Because some contracts say, in the case of this happening, well, this will be the solution, and there might be a good provision for it in the contract, in which case it's dealt with in the contract is not frustration. It must be an unforeseeable event, as per Amalgamated Investment and John Walker 1977, and there must be no default of either party, as per Eugenia 1964. If somebody's culpable, then that's not frustration. So this is a multifactorial approach. The C-Angle Edmonton Commercial Corporation against Svarliris Rus Worldwide Salvage and Towage Limited 2007 is a case in point. And here Lord Ricks said, in my judgment, the application of the doctrine of frustration requires a multifactorial approach, close quotation, which is to say they look at several factors. There's no one single determinative factor. It's a totality of the circumstances, having particular regard to the factors that I adumbrated earlier. So frustration is broken down into various categories. It could be impossibility, as in the thing that you're going to buy or sell has been destroyed, the ship has been sunk, the horse has already died, or whatever it is, the house is burnt down, the thing is now unavailable, the person you were going to hire was going to perform the contract has died or gone to jail or whatever reason is no longer available. It could be illegality, laws passed making that illegal to do. It could be that common purpose has been frustrated, or it could be leases have been frustrated. So coming on to impossibility, it could be something has died, someone has died, something has been destroyed, and this person was subject to the contract. So to buy a certain house, the house no longer exists. To get somebody to play the violin, well, she's dead. So that's as per Taylor and Caldwell 1863. Or it could be that something necessary to the contract is unavailable because we run out of whatever it is, as per Appleby against Myers 1867. So what if this thing is no longer available? Well, how badly does that impact the contract? It could be something which is tangential to the contract, possibly continue. There are various cases about this. Jackson and Marine Insurance Company 1874, or F.A. Tamplin against Anglo-Mexican 1916, indeed Bankline against Arthur Capel 1919, or Edmonton Commercial Corporation against Svarilis Rus, the Sea Angel 2007. So that last case is this Russian company, of which salvages ships, and it was about a ship called the Sea Angel. What if the impossibility is somebody is no longer available? The person could be incapable of carrying out the contract. Morgan and Manser, 1848, incapable, alive but in prison or severely ill or something like that, or died. Stubbs against Hollywell Railway Company. Obviously, you can't perform when you're dead, nor can you expect performance when you're dead. You can't demand the other person performs. And what if illegality supervenes? Fibrosa against Fairbairn, 1943. A contract to do what has become illegal to do cannot be legally enforceable. It was held. Remember, contracts which are illegal could be illegal as formed or illegal as performed, but they're void. Denny Mott Dixon against Fraser, 1944. This was government intervention because the government saying you're not allowed to do this or that because of the Second World War. Metropolitan Water Board against Dick Kerr, 1918, is another example of illegality. The purpose could be frustrated, or there could be non-occurrence of a certain event. So this must be the purpose of both parties to the contract. There was Krell and Henry, 1903, and Chant and Webster, 1904. These are the so-called coronation cases, because Edward VII, he succeeded to the crown in 1901. He's due to be crowned in 1902. So there's a coronation route, and somebody hired a room to have an excellent view over the procession route. But then the king was ill, so the coronation was delayed by some time. So the chap who'd hired the room, he could still have gone to that room at that time and looked out on the street. That wasn't frustrated, but the whole purpose of this was to watch the procession, which wasn't going to happen that day. So that was held to be frustrated, or indeed to have a good view of some sort of Royal Naval Review in relation to the coronation. There are other similar cases: Hearn Steamboat against Hutton, 1903, or Armchair Answer Call against People in Mind Limited, 2016. So can leases be frustrated? Well, that's rare. In Paradine against Jane, 1647, it said never. It's very, very rare. Some people say yes, just occasionally. The House of Lords, this was a contentious decision. Cricklewood Property against Leighton's Investment Trust, 1945. So yes, theoretically, but it's vanishingly rare. National Carriers against Panalpina, 1981. The ratio decitendi here was the property was going to be unavailable because of how long the lease was supposed to be. So did that affect the contract so badly that it was in effect frustrated? It's contentious. So remember, the frustration must either make the contract totally impossible, or at least radically dissimilar to how it was originally envisaged. It's not frustration where it's simply more difficult to perform. Ricks, Lord Justice Ricks said this in the Sea Angel, this case. He said, a test of radically different is important. It tells us that the doctrine is not to be lightly invoked. A mere incidence of expense or delay or onerousness is not sufficient, and that there has to be, as it were, a break in identity between the contract as provided for and contemplated and its performance in the new circumstance. Close quotation. So because it's become more costly to perform, trickier to perform, or whatever, or slower to perform, that in itself will not frustrate it. There are cases like this: Davis Contractors against Fareham Urban District Council, Sakir Oğlu against Nobley Thal, 1962, or indeed the Eugenia, 1964. The Eugenia is a shipping case. So where it's self-induced, this is not frustration, because this one party was culpable here. He had made decisions which led to the contract being impossible to perform, but that's not frustration, that's his fault. Maritime National Fish against Ocean Trawlers, 1935, is a similar case, or the Super Servant 2, 1990. When people couldn't use the Suez Canal one time, had to go around the Cape of Good Hope, the contract was not held to be frustrated. Even though it was going to be slower and more expensive to perform the contract, nevertheless it was still possible to deliver the goods. So the burden of proof is on the party who says there's frustration here. Joseph Constantine, Steamship Limited against Imperial Smelting Corporation, 1942. So the onus is on them to demonstrate that it really is frustration. So it's not frustration if the event was foreseen, or at least foreseeable. There's Walton Harvey Limited and against Walker and Home Freights Limited, 1931, or indeed the Sea Angel, which I previously mentioned. And Lord Justice Rick said this: the less that an event is foreseeable, the more likely it is to lead to frustration. And by implication, the more foreseeable it is, the less foreseeable it is, then the the more unforeseeable, the more unlikely it is that it's frustration. Foreseeability, armchair answer call against People in Mind Limited is a case about that, or indeed the Flying Music Company against Theatre Entertainment Société Anonyme, 2017. So the contract might provide for this scenario. There are these force majeure clauses, okay, such if it becomes impossible, then there's frustration. If this happens because of weather or war or whatever, boilerplate drafting that they call that, providing for all these possible eventualities. So there could be an express provision in the contract to say what shall transpire if certain events occur. So this might be deemed to be parties providing for the risk, and it's hard to say that his frustration if they've explicitly provided for it. Okay, so what happens if frustration is declared? That means that future obligations are no longer binding from the date that the frustration event occurred, not from the date that the court ruled on it. Because the court might rule that on the 1st of June, but the frustrating event was the 11th of March or something. So therefore, from the 11th of March, the performance could cease. So any money paid or anything accrued before the frustration, if there's a total failure of consideration, this is usually recoverable advanced payments, or they're no longer payable, anything you're going to pay later, as per Fibrosa and Fairborn. However, there's partial failure of consideration, then any advance payments are not recoverable or remain payable, like Chandler and Webster. So there's the Law Reform Frustrated Contracts Act 1943, significantly was passed during the Second World War because, owing to the war, many contracts were frustrated, consequent upon things being destroyed or trading with the enemy being illegal and so on. So this act applies unless it's specifically excluded. So section 1.2 says any money paid in advance of the frustrating event is recoverable. Moreover, money payable before the frustrating event is no longer payable. So it goes on to say in section 1.2 that expenses can be recovered. So a party who has run up some expenses must demonstrate that it is just for them to keep the money that's spent. So a just sum will be awarded as the court deems suitable. So there is a limit to how much money is going to be paid before the frustrating event, as per Gamco essay against ICM, Fair Warning 1995. So section 1.3 says if a valuable benefit has been bestowed, if one party has given something which is non-pecuniary an end product before the frustrating event, the other party might have to pay a just sum for that product, as per BP Exploration against Hunt 1979. So in section 2.3 it says parties can contract out of the Act. They could put a clause in there saying that the Law Reform Frustrated Contracts Act shall be disapplied to this contract. Section 2.4 says there could be many different obligations, such as per leases. And section 2.5 states that contracts can be excluded, certain contracts that are excluded from the Act, usually the transport of goods by sea or insurance contracts. So that is the end of frustration. Make sure you subscribe and make sure you book online lessons with me in law, various subjects like history, politics, French, religious studies, geography, English language, English literature, and so forth. Toodaloo.